Started. Today we're doing lay and expert witnesses, and hopefully we'll get to our hypothetical, which is actually a real case. It's from the case that we'll be doing is Shallock v. Hines, which is a civil rape case. Hey, you guys, I'm talking here. A civil rape case that was broadcast on Court TV on one of their trial stories. So hopefully we'll get to that by the end of class. Today's experts, lay and expert witnesses, but we'll mostly talk about expert witnesses. And expert witnesses are the one kind of witness that you can actually hire for your case. So if you do, if you're in private practice, just about every case you have that you go to trial, certainly if you go to trial, you're going to hire an expert. Because, you got the money, you do it. If you do, say, criminal practice, you don't see experts in that many cases, but you tend to see them in any high-profile case. You'll get at least one. Of course, medical experts are quite common in criminal cases. But what we'll be looking at is a psychology expert, because it's the psychological testimony that is often most controversial and I think most interesting. Of course, that's partly because I'm a half psychologist. So what we'll do is first talk about lay opinion, the extent to which that lay people can go beyond the facts, just the facts, and express opinions. And you'll see it's a pretty narrow allowance. That is, lay people are not expected to come into court and opine on everything. They're supposed to stick to the facts. We'll then look at the very broad rule with respect to expert opinion. Experts, the great thing about experts is the fact that they can express their opinions. They can come to conclusions, and they can suggest those conclusions to the jury. And so they can be highly influential in helping you to essentially put together the disparate facts that you present in order to make an argument to the jury before you get to your argument, okay? And we'll see the basis for expert opinion, the qualification requirements, the usual. In Rule 703, we'll see a special rule with respect to the what's okay for experts to rely on. One of the things that we've talked about a little bit before is the fact that you have to have personal knowledge, right? You remember that rule, personal knowledge rule? Which leads us into the issues with respect to hearsay, and you'll see today leads us into the issues with respect to you can't go beyond your personal knowledge to express opinions that have no basis. It turns out that experts can rely on anything. So experts can give their opinion based on hearsay. Experts can give their opinion based on inadmissible evidence. And so in addition to the fact that you like experts because they can form conclusions, unlike lay witnesses, right? You also like experts because they are often a way to get around the problem that some of what you want to get to the jury is inadmissible. Now, of course, because this is an end run around the rules of admissibility, there are restrictions on it. And so we'll talk about those restrictions and to what extent you can get around those. Yet another great thing about experts is experts are allowed to not only give their opinion on issues that are important to the case, but they can give their opinion on issues that are essential, that have the effect of making or breaking the case. And these are what we call ultimate issues. Now, if you come to this without any knowledge of evidence at all, you might say, well, of course they can talk about the most important issues in the case. But it turns out that traditionally, classically, under common law, there were restrictions on giving opinions on ultimate issues. The expert could not turn to the jury and tell the jury how they should decide. Those rules have mostly been relaxed and all but eliminated. And we'll see in a few cases the courts will still use this aversion to ultimate issue testimony, but for the most part, it's okay. And then Rule 705 is, what do you do about the problem of doing an end run around the rules of admissibility? And what we'll see 705 does is 705 says, well, we're going to allow, excuse me, we're going to allow experts to rely on inadmissible evidence, but we won't necessarily allow the experts to tell the jury what that inadmissible evidence is, okay? So it's basically a way of avoiding the problem that 703 could be so abused, you would be able to give lots of inadmissible evidence, get in lots of inadmissible evidence. And finally, we'll talk about a series of cases in which the Supreme Court has interpreted 702, some of which has been now built into amendments to 702. So some of this is redundant, but to some extent this is new because what these cases deal with is the special problem of what you'd call scientific evidence. And scientific evidence leads to additional requirements by the court with reference to, how do you determine what science is? What is scientific? And so we'll talk about things like peer review, which is the way the scientists think. Scientists say that you are publishing acceptable science if you're in a particular journal that is subject to referees, that is subject to peers, other scientists looking at your work and saying whether they think it's credible. And hopefully Shalak. Okay. So first, let's get moving with the rules. I'll give you the rule and tell you what to write. This is the rule with respect to lay witnesses. If the witness is not testifying as an expert, the witness's testimony in the form of opinion or inferences is limited. So if you're not an expert, how much opinion you can give is going to be limited. And here's what you want to write. If the witness is not an expert, opinions or inferences must be, suspense is killing you, rationally based on the perception of the witness. Okay. Rationally based on the perception of the witness. And, again, more suspense. You want to write, helpful to the jury. So if you're a lay witness, in order to express an opinion, it has to be rationally based on your perceptions, and it has to be helpful to the jury. Now, this all sounds like pretty wimpy language, and it is to some extent, although it does have some meaning that we'll flesh out. And here's a new piece of the rule, and I want you just to write this, because the reason for this new piece of the rule, or new within the last 5 years, is you can't avoid the requirements of Rule 702, which have to do with what experts can and cannot do, by offering expert testimony as lay testimony. Okay? Now, since we're doing 701 first, this seems a little odd because you don't know exactly what 702 is. But I can tell you, the point was this. I got a little hot spot here. Okay, I'll step over here. Oh, that's better. The point is this. When they toughened up on experts, and they did this around the time of Daubert, and what happened is experts were getting into court in these big tort cases, toxic tort cases. And these experts were willing to say what seemed like outrageous things, at least to the defense attorneys. They were willing to say that even though study after study after study had not found a significant association between, let's just take one case, Bendectin litigation, between Bendectin and birth defects, even though study after study after study had not found an association, there were experts who were willing to come into court and say that an association existed, right? Well, how could they say that? Well, it turns out that they actually had really solid grounds for saying it. And the reason had to do with statistics, right? It had to do with the fact that each independent study on its own didn't have what you'd call sufficient statistical power to find an association, even though the association might exist. And what these experts were is epidemiologists whose job is to look at the effects of, say, toxins in large groups. They're statistical experts. And these statistical epidemiological experts were willing to come into court and say, even though study after study didn't find an association, there are reasons to think that an association existed. Got the defendants all upset. They're drug companies. They got to get these cases out by summary judgment. If they don't, and the case even looks like it might get to a jury, they're going to settle, and it's going to be big bucks, because what Bendectin purportedly caused was birth defects, and what birth defects means is mom, dad, deformed little baby, and a big drug company on the other side. Right? You don't want to go in front of a jury with that kind of case, even if there's no causality at all. Just the fact that the kid's looking really bad, and the mother said she took Bendectin during pregnancy, boom. Right, you lose. So the drug companies said, you've got to stop this you got to stop these experts. And the rules were wide open. Experts were getting in all the time. And so it went up to the Supreme Court, Daubert, Supreme Court struck down the liberal rules of admissibility for expert witnesses. Rules now are tough, okay? And that's what we'll see today, is how tough 702 became. Well then, in response to that, plaintiffs thought, well, wait a minute, maybe we don't have to present our expert as an expert. Maybe we can just present them as a layperson and get in under the liberal rules for opinions with respect to 701. Now, this didn't happen in toxic tort cases. It's kind of hard to present a PhD epidemiologist and say, oh, no, she's just going to express her personal opinion, right? It doesn't work there. But in many cases, criminal cases, they started to let in experts as lay people under 701. And this rule then popped up. They said, uh-oh, you can't use 701 to get around the rules of 702. Okay? Well, why do we care about opinions, right? You can either think opinions, we never express our opinions, we always express just what we see and what we heard, or you can think everything's an opinion. But 701 assumes that there's a very clear distinction between facts and opinions. And let me give you an example of how difficult this distinction is, right? When I tell you there's a chair there, is that a fact? Am I expressing simply my perceptions, or am I expressing an opinion? Well, you know, you probably talked about this in one of your intro philosophy classes in undergrad. It's kind of hard to say, right? Because you could say, well, yeah, it's a fact that it's a chair. But then you ask me, well, why do you know it's a chair? And if I really think about it, I say, well, it doesn't just pop into my head that it's a chair. I look at it, and I see that it's shaped in a certain way. And I see that many of you are using it as an object upon which you rest your buttocks, which, as you know, is the definition of a chair, right? An object to which the buttocks can be rested. And therefore, it's a chair. Well, that's an opinion. And so 701 says, hey, wait, there's got to be a limit on this. So you've got to stop and say, okay, when am I going to make an opinion objection? And when am I going to allow it through as a fact? And that's why you need to be able to distinguish facts between facts and opinions. Well, if you think about it, that conclusory statement, it's a chair, is based on what I see, right? But it's coming to a conclusion about what I see. And if I was really forced to say just the facts, then I would say, okay, I don't see a chair over there. What I see is an object that is, you know, shaped it actually shaped like a bottom, right? It's got a nice, I mean, that's the most comfortable chair. It's a chair that really is shaped like your buttocks. And it's got a thing that would fit a back, right? And it's elevated up off the floor, therefore it's a chair. Well, to make a long explanation short, my immediate sensory input is the fact, right? Just what I see, just describing what I see. And as soon as I start concluding things based on that immediate sensory input, in light of what I know, I have learned the word chair to describe a buttock support system, then that's an opinion, okay? Now, the way I've described it to you is everything starts sounding like an opinion, and you realize you can push it that far. So the line is sometimes hard to draw, okay? But since everybody knows the word chair, everybody learns chair at such a young age, we call that a fact. Now you get to where you're a slightly older person and you learn lots of more sophisticated things. So like I look at your computer and I say, oh, you know, that must be, and I don't even know what they are now. Are they still using Pentiums? So that must be a, do we still talk about it that way? Last time I checked, we would talk about like, oh, that's a Pentium 500 or something, right? And notice that just my fact that I don't really know what I'm talking about, you say, hey, that sounds like an opinion. So to the extent that it's more arcane, more sophisticated, requires more knowledge, then it starts to look more and more like an opinion. Facts are specific. Opinions are more general. Now, what do I mean by that? Well, if you think about it, when you express an opinion, that is a conclusion based on a number of different facts. So it's got that overview of the facts. Whereas as you break things down and look piece by piece, so as I describe the different elements that lead me to conclude that that is a chair, that's more specific. So that's one way you can spot a fact, is it's more specific. And my Pentium example brings this out quite clearly, I think, facts are more certain because you're directly reporting what you perceive, as opposed to less certain where you're interpreting it, because you could always be wrong in your interpretation. Okay, now this comes up all the time. So the policeman testifies, you know, that I walked to the front of the car and I asked for his ID. Did he appear drunk? Objection. That's an opinion. And that might be sustained. Okay? That might be sustained. Now, of course, you have objective ways of determining if someone is legally over the limit, but there may be questions about whether the policeman had sufficient cause to investigate further. Well, what would an attorney do if faced with that objection? He'd have to conclude, yeah, this is a conclusion based on what the officer saw. So then he might say, okay, well, what did you base that opinion on? And in doing so, he basically asked, well, how did he look? Right? What did he say? What was his speech like? Right? Was it slurred? How did he smell? Oftentimes, officers will have a keen sense of smell, and they'll smell all sorts of things. So you want to be careful. So if you refuse to roll down the window, for example, and when you do roll down the window, if a huge amount of smoke comes out, it might not necessarily mean you're drunk, but it might mean something else, right? So those are all more specific, more factual, and that's the way you would get around an opinion objection. Okay, so now you know the difference between facts and opinions, despite the fact that it's puzzled philosophers for thousands of years. Why do we prefer facts? The rule 701 says facts are better, right? Facts you don't have any 701 objection to. And the reasons for this are pretty obvious. They're more likely to be correct, because as soon as you start interpreting something, right, you add pieces of potential misinformation. Your knowledge might be inaccurate. And notice that facts are good because we have these people we call fact finders. And the fact finders are the ones who can draw inferences. So if the jury hears, right, that he did this and this and this and this, the jury can conclude that he was drunk. And that is the jury's job. On the other hand, 701 doesn't deny opinions, right? It doesn't preclude opinions. Opinions are better than facts because of the fact that they are more general, right? Because they're more general, they're more efficient. It takes a long time to explain all the different reasons why I think that's a chair, and it gets pretty boring. And so just say it's a chair, right? If it, you know the expression, if it walks like a duck, talks like a duck, it's a duck. That's more efficient. And this is the most interesting thing. Some facts are difficult to describe. So was he angry? Yes. Objection, opinion. And if you think about it, saying that someone was angry is a very opinionated thing. You're basing it on a lot of different perceptual inputs that are then leading you to conclude that the person is angry. And although in many cases, anger can be easily demonstrated based on the facts. How do you know he was angry? He said, I am angry. That would be easy. But imagine, have you ever thought about this? Can you describe in detail the facial muscles behind anger? This is actually the source of study, right? Can you describe the voice inflections that mean anger? And this is something that people who do computer processing of language now work on, because you know when you call have you ever talked to a computer? Hello. And I don't mean the movie phone, because he doesn't really talk to you. But where they say, hello, what is your number? And you say the number, and then he says, what would you like to do? And you're actually talking to the computer. Have you ever done this? It's really exciting. It's what I do instead of chat lines, right? I talk to computers. And what the computer is programmed to do is to register when you're angry. And the way they do that is they program the computer to recognize when you have certain rising tones. I'd like to talk to a human, right? Then it will switch you over to an operator. And actually, next time you talk to a computer, try that, right? Try that. Just try yelling at it, and it will probably switch over if it's got this software installed on it. It's actually people at our engineering school who do some of the cutting-edge work on that, detecting anger. Okay, so because facts are better in some ways, opinions are better in other ways, the compromise solution is to allow lay opinions as long as they obey the rules. You don't have to write this down. This is already in your notes, right? And how does this then solve the fact versus opinion problem? Well, if they're rationally based on the perception of the witness, that reduces risks of inaccuracy, right? Remember the objection, speculation? Speculation, you might say, is just an objection to opinion. But the difference between speculation and opinion is speculation is when it just comes out of thin air, right? But if it's rationally based on your perceptions, then it's a valid opinion. and helpful to the jury gets at this issue of efficiency, right? Sure, the jury can decide on their own. We prefer that, but there are cases where it's just better to let the person tell the opinion. And that would also apply to the facts are difficult to describe issue. It's helpful to the jury if you're not forced to try to say that, you know, the facial muscles around the forehead were constricted. Okay. Let me ask you some questions, and you tell me, are these admissible as lay opinion? You don't have to use your clickers for this. It was James. Objection, 701. Well, there has to be foundation for knowing who James is, but that's certainly okay. This is James' signature. You remember authentication, right? Remember the rules of authentication. Do the rules of authentication assume that lay people can make handwriting judgments? Mm-hmm. The only limitation is they can't acquire their expertise for the purposes of litigation. And notice that's like a lay person who's acting as an expert. So authentication rules have already told us that's not okay. But as long as you just know what James's signature looks like from your incidental exposure to his handwriting, that's considered okay. Now, this is like the one I gave you before, the drunken. Oh, wait, no, I switched the order around from my old note. Sorry. James weighs about 240 pounds. I think you need an expert, right? That's the reason why we have guys working at the circus doing this. Because it takes an expert to guess your weight. But the courts don't care. The courts don't care. Let's say you're standing on the street corner and a car drives by, and you want to testify that James is going 90 miles an hour. This seems ridiculous, right? You have no idea. You don't have a stopwatch. That's okay too. So actually, although the rules sound pretty tough, when you get into actual practice, the rules are very lenient. And let's see about this, okay? Because you might think, well, 240 pounds, that sounds about right. Let me ask you a couple questions. How tall am I? Oh, yeah, can you speak in feet and inches because of my Western bias? I don't even know how long a meter is. I'm sorry for our LLM students. 6. Do I hear 5'11"? Anybody? Sorry, that's a leading question, wasn't it? It turns out this is correct. Okay, you're pretty good, pretty good. A lot of people, though, will be in my class all semester, and at the end of the semester, they'll come up. They'll finally be brave enough to ask a question after class. And when they come down here and look at me, they're like, oh, my God, you're actually tall. Okay, this is a little tougher. How much do I weigh? What was the number? 200? 205? Boy, I should show you the tape from 10 years ago. Yeah? 230? Oh, yeah, I shouldn't have told you that. Now you're doing that weight height calculation. It's getting heavier and heavier. Any higher? 190? Thank you, ma'am. What are you doing after class? It turns out that, well, I haven't weighed myself recently, but it's closer to 230 than it is to 190. Now, of course, you're looking at me and thinking this. But what we do all the time when we ask people is, and you know, that's the reason why in 7-Eleven they have the how tall you are on the door, because of robberies. Because they tell the store clerk when he leaves, you know, check to see how tall he is. I always thought it was so great. I thought 7-Eleven, you know, it's like you bring your kid to 7-Eleven and you see how tall he's becoming. That's not the reason at all. So, but notice that you're looking at me and you're trying to decide how tall I am. But if we had some incidental conversation, and then later you were asked how heavy was he, you'd have to reconstruct from your memory and it would be that much harder. But that would all be totally admissible, even though you're like as much as 40 pounds off. Now, the speed thing is really interesting. How fast did I go? Seven. Actually, I went over 30 miles an hour. Okay. And you can watch the tape later and see that proof. All right. So very difficult, some of these. I saw James at 3 a.m. Now, were you looking at a clock when you saw James at 3 a.m.? Maybe. Oftentimes, you know, what happens is you're woken up and you say, do you know what time it is? So you do look at a clock. But let's say you're partying all night, and James shows up at the door in the middle of this all-night party. Well, courts don't care. They would allow this. Now, one thing that's interesting with kids is kids are asked these kinds of temporal questions all the time. So they'll say, how old were you when it happened? Was it around a Christmas? Was it around a holiday? Was it before or after? And prosecutors think they're getting away with murder because they get the kid to say something, and then they charge him up on that date. But what they're really doing is just giving the defense attorney a gift. Because what the defense attorneys can easily do is confuse a child when it comes to time. And there's no evidence that kids have any ability to do this at all. And I've actually played with my kids this way. I asked my son, you know, how many times he'd been to Legoland. And he looks like he's really figuring it out. He goes, I think 3, right? Which is wildly incorrect. And if I asked him on another occasion, he'd give me some other exact answer. It doesn't make any sense at all. James was angry. Now remember, this is opinion. You could argue about this, but the judge is going to allow it. James was high. That sounds like a really subjective judgment, but that's okay. I got the impression James knew there was dope inside, and I think this is from your treatise. This might not be allowable, right? Because one of the things that courts do like is an objection, calls for speculation about the mental state of another person. So we are not presumed to have special insight into other people's mental states. And here the court would say, you know, break it down. Just the facts, ma'am. Just the facts. Okay? Okay. So lay opinion is actually pretty wide open. The way in which courts will restrict lay opinion in a real and meaningful way is if a layperson is basing their knowledge on something other than their direct perceptions. And as you already know, 702 is going to allow that for experts. And they're also not going to allow lay people to make what sounds like an expert judgment. Okay? Anything that sounds like something that an expert would be able to do sounds like something a layperson cannot do. And so you really have to look to 702 for that expert opinion. And here's 702, and I'll just give you the rule and then tell you what to write. If scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact and issue, and what you write is, because this is the way that they've construed the rule, expert testimony, parentheses, based on scientific, technical, or specialized knowledge is admissible if it, A, will assist the jury. Okay? So we've already got a sense of what experts are supposed to be experts based on, right? They have some kind of special knowledge, which we call scientific, technical, or specialized, and we will talk more about those terms. We have the assist the jury requirement, which we've already seen with respect to 701. A witness qualified as an expert by knowledge, skill, experience, training, or education. So you want to say, so A is the requirement that it assists the jury. B is the witness has to be qualified. And this I'm sure you've come across. Oh, I guess if I'm close to that speaker, then that's what causes the problem. I'm finally figuring out sound in here. So I'll stay away from there. And if B, the witness is qualified as an expert by knowledge, skill, experience, training, or education. And this sounds like a lot of the same thing, but you do want to write that down because you'll see how you can be an expert for many different reasons based on that list. Okay? B, and if B. And finally, C. C is going to have some subparts. May testify thereto in the form of an opinion or otherwise if the testimony is sufficiently based on reliable facts or data. Now, the way you want to write this in your notes is say, and if C, the testimony is 1, based on reliable data, okay? So this is the data has to be reliable. I'll write it in a second. The testimony is the product of reliable principles and methods. So write 2, the product of reliable principles and methods. Okay, reliable principles and methods. And finally, and 3, the witness has applied the principles and methods reliably to the facts of the case. So 3, the witness reliably applied the principles and methods. Okay, so remember, so those 3 requirements, and this comes up, and this rule was adopted, this piece of the rule, that last 1, 2, 3, that's relatively new, and that was adopted after Daubert. And that was really responding to the issue of scientific testimony. You have data, principles and methods, and 3, application. Now, let me say a few things about this. Data, of course, is just a fancy word for facts. When you're a scientist, you call facts data. Makes you sound good. Principles and methods, of course, are the things that you learn through your expertise. So they're generalized ways of putting facts together. And application is, you might say, well, this is application, right? Principles and methods. But application specifically applies to this case. Because a lot of times the data and the facts that the expert comes in equipped to talk about are those data and facts that he or she has learned as part of being an expert. Like you may know what rape victims are like, that we'll see in Shalak v. Hines. Well, those are data and facts. But what this victim or asserted alleged victim is like is a fact of this case. And so notice that when you're talking about data and facts and principles and methods, the expert often may know nothing at all about this case, and you have a 1-2 question. But the 3 question comes in when you say, okay, now that we have established the fact that she knows about a lot of rape victims and that she has a coherent theory for explaining the behavior of rape victims post-rape, does she legitimately apply that knowledge to this case? And this last piece is something that is often called fit, right? In Daubert, it's called fit, and that will be a helpful term to remember. And it's in some ways a conditional relevance issue, right? And think about it this way. Why is it a conditional relevance issue? Well, remember conditional relevance? Someone says, is it relevant? So I have an expert who knows about rape. She's seen lots of rape victims. She has a theory called rape trauma syndrome that's based on, peer-reviewed publications. And I want her to testify. And is her testimony relevant? And I would say, well, it depends. Well, what does it depend on? It depends on whether what she's saying has to do with the specific facts in this case, right? It depends on whether there's a connection between what she's testifying to and the symptoms that are actually attributable to the victim. And remember when you say relevance depends, that's a conditional relevance issue. And what does that require? Well, that requires facts sufficient to support a finding. But notice that because 702 writes this into the rule, this is the language of the rule, it becomes a decision for the judge to make. So this is one of those cases where something looks like conditional relevance, but because it's explicitly spelled out in the rule, it's something that the judge will decide. Now, why do I say a lot about that? Well, if you're a civil litigator, it matters hugely, hugely whether something is an issue for the jury or the judge, right? And you know why that is? Because when you get to summary judgment, if it's an issue for the judge, you can get the case kicked out if you're the defense based on this fit argument. If it's an issue for the jury, the plaintiff has every right to say, Your Honor, this isn't for you to decide. You should let this case go forward. So that change in 702 is huge. Okay. Now, note that the rule allows the expert to testify in the form of an opinion or otherwise. And here's what you want to write. Make sure you have this in your notes, is that expert witnesses may state opinions. It is clearly distinctive in that experts can go far beyond the lay witness. Okay. All right. But 702 has the requirements of must assist the jury, must be qualified, and 3 must be based on these principles. Okay, let's do that first one, assist the jury. What does assist the jury really mean? What does it really mean? Well, it used to be that courts would not allow expert testimony when it was not, quote, beyond the ken of the layperson. And what they meant is it's something everybody knows. And this kept out a lot of psychological expert testimony. It didn't keep out as much medical testimony because doctors, medical doctors at a very early stage in training learn to say everything so that it sounds scientific, right? And you know how insulting it is when you go in and the doctor says to you, you have a cold? It's very insulting. Because the doctor is saying to you, you have something that you could diagnose. But if you go in and the doctor says, you have sinusitis, you have rhinitis, you have bronchitis, you have something else itis, you feel good. And you know the chances that he's giving you a drug are probably 10 times if he says rhinitis than if he says cold. But he's saying the same thing. I learned this recently because now that I'm a professor and I went to go see a doctor, he said, you have bronchitis. Here's some drugs. And when I went as a student to the same kind of medical place, they would just look at me and say, you have a cold, get out of here, right? So I have the prestige now that I can get drugs for a common cold. But anyway, I'm getting back to the psychology problem. Psychologists talk in ways that people understand, and they often were excluded under this beyond the ken, because they'd say, well, everybody knows what happens if you're raped, right? You act upset. Or maybe you don't act upset because you want to hide the fact you were raped. Everybody knows that. That is no longer a valid objection. Assist the jury doesn't require that something be totally outside of the range of common experience. Okay? It helps. It will ensure that your expert gets admitted if you can say it runs counter to intuitions that people have. And you'll see that with rape trauma syndrome, is aspects of it are counterintuitive, but it doesn't have to lie beyond common experience. And that's an important thing to know. Okay? So it helps, but it doesn't have to. It's sufficient, but not necessary. If it is within common experience, then the language that you use in objecting to it is you say it invades the province of the jury. Okay? It invades the jury's province. Now, this language itself is considered archaic, out of date, incorrect. And you'll see language in the advisory committee notes that says we no longer talk this way. Courts still talk this way. And basically what you're saying is you're saying, look, when you bring an expert in to say something that is obvious, and you tell the jury he has this PhD, and he has that degree, and he has these years of experience, you're telling the jury that even though what the expert says might sound commonsensical, the jury should defer to the expert. And what deferring to an expert who doesn't have any special reason to know means is the same as invading the province of the jury. The jury wants to give up their responsibility to decide the case. And actually, if you ever sit on a jury, you'll get this feeling. You'll realize how awesome it is. And I mean awesome not in the, wow, it's great, but awesome it is to have to decide the fate of someone, even if it's a civil case and it's just money. And if an expert comes in and tells you exactly what you know already, you feel good because you can say, well, the expert said, right? You can lose your sense of responsibility for the case. Because of that risk, then courts will not allow experts that are simply saying what everybody already knows. And that's the way you want to argue it if you're opposing an expert. You say, takes over the jury's province, tells them what they already know, risks prejudice, right? Because the jury will decide not because of the facts, but because they want to defer to an expert. The second requirement is you've got to be qualified. And this, I'm sure you've seen on TV or you've gone to see a trial. There's this long extended getting the CV into evidence. Where did you train? I made the mistake, one of my first child abuse cases, I called up a number of experts, none of whom had any time, and I was thinking, I'm not going to get an expert. And then someone slipped me a number of some random doctor, and I called him up, and within 10 seconds, he was ready to come in and testify. And I should have smelled a rat, right? I should have recognized that, wait a minute, why is this guy so anxious and willing to be an expert? And then when he came into court to testify, I made the mistake of going very carefully through his training and experience. And when it got to the point that he had gone to, well, I won't name any names, but that he had gone to a medical school that was in a different place with different standards and had a reputation for admitting students who had basically partied all through their undergraduate years, I noticed how his voice dropped when he mentioned the medical school that he had gone to. And it was at that point I realized, oh, I've come across a hired gun, right? I've come across a professional expert witness who routinely will testify for the prosecution in child abuse cases. It didn't matter to the judge. Medical degree, you could get it from anywhere. You could get it from a place that you found out about on the back of a matchbook. You know, they used to advertise on matchbooks for vocational schools, because that dates me. But anyway, let's say you get a GP to come in to testify, and the testimony is about child abuse. Doesn't matter. Let's say, specific example. What if the defense in that case, remember the case, Rainmaker, had brought in the family doctor to say this is an incurable form of leukemia? Would it be a basis to object to his testimony that he's just a family doctor? No. It would be a reason to question him on cross-ex, but it wouldn't keep him out as an expert. What if the person is not renowned? Well, of course, that doesn't matter. In fact, it's kind of hard to be renowned and do a lot of expert testimony because it takes up all your time. What if the person has no experience whatsoever? Well, I don't want to make fun of any of my colleagues, but do you have to be a practicing lawyer to become a law professor? Luckily, no. That's okay. And I get as much mileage as I can out of my limited experience as a real lawyer. So that's all right because we are so well educated, right? I say that with a little bit of trepidation. What if you only have experience? Well, of course, you're not going to be a lawyer with no training, but I'm sure you've seen that. You recall that scene from My Cousin Vinny, where, what was her name? Marissa Tomei, who kind of like got the Academy Award and then disappeared. She testified as an expert in auto mechanics because she had lots of experience in playing around in the garage. And actually, not just playing around, but she was extensively experienced without any training whatsoever. That's okay. You can be self-taught. Okay? So this requirement is not very stringent. Not very stringent. Skill doesn't require much of anything. All right, so back to a real rule. 703 talks about the bases of opinion. And remember that one of the special things about experts is that they can rely upon inadmissible evidence. And this is what 703 helps us to understand. It says that the facts or data in the particular case upon which an expert bases an opinion or inference may be those perceived by or made known to the expert at or before the hearing. So what rule does this contradict? Personal knowledge, 602. Doesn't have to be based on personal knowledge. It can be made known to. Now, it says at or before the hearing. Sometimes, well, let me put this up and then say what I was going to say. Expert witnesses need not have personal knowledge of the facts upon which they base their opinion. What I was starting to say before I said that was sometimes the expert will actually come to the hearing and watch witnesses testify. Now, that's expensive because they've got to sit there. And, you know, experts don't come cheap, it tends to be, if you're a good expert or if you work for the big bucks. And they can do that, or you tend to send them like transcripts, depots, that kind of thing. Now, the rule is concerned about the fact that now we're going to indirectly admit all sorts of inadmissible evidence. And so it does require this. And don't write this. I'll give you a skinny version. If of a type reasonably relied upon by experts in the particular field informing opinions or inferences upon the subject, the facts or data need not be admissible in evidence in order for the opinion or inference to be admitted. And the way to write it is, expert witnesses can base opinions upon inadmissible evidence if that evidence is reasonably relied upon by experts in the same field on the same subject. Okay. And this is huge, right? This is huge because you might have some hearsay that cannot be admitted, but you can give that hearsay to an expert, and an expert can come into court and testify, in my opinion, right? So, in my opinion, the cause of the crash was Cindy and her 5 drunk high school friends. Do you remember that case? There was an issue about the admissibility of the officer's report. Conceivably, you could hire an expert who could come into court and say, in his opinion, she was responsible for the accident. The expert could, in part at least, we'll see how there's limits to this, but in part at least, the expert could have read this wholly inadmissible report. And what constraints are there then on you hiring some random guy to come in and say, oh, I read the report and here's what I think? Well, as long as he or she's doing what other experts in the same field do. So you take a medical doctor. You give the medical doctor those medical records. Imagine that case we talked about with, and I always remember facts and not the names of the cases, so of course you don't want to worry about the names as much either. Remember the case where the fellow said that it was a severed nerve, and that it was during the first operation that the nerve was severed, and it was all inadmissible, potentially, but he could have hired a medical expert who would then, at first thing off, say, give me all the medical records. And if you could prove that other experts who are medical doctors would read medical records in order to form opinions, and they do, then you could allow that expert to come in court and say, I believe that the nerve was severed. See how big the rule is? Now, here's what 703 starts to do to limit the potentially prejudicial effect of this wide open rule. And I'm just going to give you the skinny, not even bother reading this. Oops. Is when the expert bases her opinion on inadmissible evidence, okay, when this does happen, the jury can hear about that evidence only to assess the expert's opinion. Now let's stop there, because you want to think, well, is this a real restriction? What they're saying is when the jury hears that you read those medical reports, the jury is not supposed to believe those medical reports. The jury is only allowed to say, do I believe the expert, given that he relied on those reports? Now chew that over for a while and see if as a layperson, see, as a lawyer, let alone a layperson, you can understand that distinction. Does that make a lot of sense? I'm not listening to the medical records to conclude that the medical records prove that, say, the nerve was severed. I'm listening to the medical records so that I can decide whether the expert could reasonably conclude that the nerve was severed. And the judge will give the jury this kind of instruction. That's not very helpful, but that's the distinction. It's much like the distinction between hearing a prior inconsistent statement to assess credibility and hearing it to determine truth. It's a lot like that very difficult distinction we've discussed before. Now, and if that evidence is offered by the proponent of the testimony only if probative value outweighs prejudicial impact. What does this mean? It's inadmissible. It can't be offered. But here's what can happen. The person who offers the expert, let's say this medical expert who's read the medical records, wants the expert to say, I believe the nerve was severed. That plaintiff also wants the expert to say that the reason I think the nerve was severed was because it says so in the medical records, right? That would be offering the medical records, not as proof of what they assert, but as a basis for the expert's opinion, okay? And what 703 is saying is that if you do that, you have to obey a higher standard of admissibility than 403. You have to prove that probative value outweighs prejudicial impact. Another way of saying this is the rule is very skeptical of allowing the plaintiff or the proponent to tell you why the expert thinks what he does if the basis for what the expert thinks is itself inadmissible. Okay? That's the way to intuit this, is expert gets up in the stand, says X, Y, and Z. What do you base that opinion on? Objection, that's inadmissible. And the court says, well, I'm going to allow him to tell the jury what he based his opinion on, and I'm going to tell the jury, this isn't for the truth of the matter, this is just so you can assess his expertise, right? You'd say, no, it's got to obey this higher standard in order for you to tell the jury what the basis of your opinion is. Okay, I'll stop there because that's difficult. Kind of makes sense a little bit. All right, well, let's go back to this wonderfully open allowance. And we'll come back to that, trying to restrict how much inadmissible evidence gets to the jury as a result of that allowance. So what are the things that experts can do? Of course, don't forget that the doctor can have personal knowledge. That is certainly okay. So if you get an expert, you definitely want him to examine, well, unless you've got a really lousy client, you want him to examine your client, assuming he's going to be testifying about the conditions of your client. So, you know, first thing you do when you call, what is it, 222-2222? Yeah, on the back of the bus? And it's so great because I'm sure a lot of times someone has an accident with a bus, and you're injured and you look up and you see, you know, avocado, 222-2222, right? And you're thinking, God has come to me at last, right? Because in the form of a bus accident that will accrue me millions of dollars. Well, when you call 222-2222, who do you suppose they send you to? Do you go see the lawyer? I'm not even sure you go see the lawyer. I think they might first have you go to see a doctor. And that doctor, of course, is, you know, Miss Dr. Nick. Hi, everybody. And Dr. Nick will say, yes, you have some kind of back pain that cannot be diagnosed via x-rays or any other kind of physical examination. That is okay. In fact, that is the preferred method of some types that you would never go into of private litigation. The information gathered in court is okay, so you can go to the trial. Hypothetical question is the old-fashioned technique for getting in lots of inadmissible, well, not necessarily inadmissible, for getting in, let me put it this way. Hypothetical question is the way that you deal with the fact that the expert might not be present at the trial and might not be privy to all the testimony. So what the hypothetical question does is say, doctor, I want you to assume the following facts, and then you basically summarize the testimony thus far. And if you think about it, you realize, oh, that's a way to get an argument before the jury, right? That's a way to summarize the evidence before the jury. And that's why hypothetical questions are still used, even though they're not necessary. The expert can gather information outside of court, and of course, that would raise personal knowledge and hearsay issues, but 703 says that's okay. Okay. Well, we've already talked about one way in which 703 tries to limit this very liberal allowance of the bases for expert opinion. And it does that through that weird distinction between what the jury can hear for its truth and what the jury can hear as a basis for examining the expert's opinion. And we've seen that if the evidence is inadmissible, then you may not even be able to tell the jury about the basis for your opinion. And we'll come back to that in 705. But outside of the rules, there are other ways that the courts have tried to limit this very broad, expansive view of what experts can rely on. And here are some potential limits based on the common law. If the expert is solely relying on other experts, so the expert isn't really adding any of his own or her own expertise, but is simply quoting other people. And what you might say is this is blatant disregard of the hearsay rule. And notice that this is unfair because it violates your ability to truly cross-examine. Right? What was the basis for your opinion? Well, the basis for our opinion was Dr. Y thinks so. Well, why does Dr. Y think so? Well, I don't know. You have to ask Dr. Y. Right? So this is a problem, and some courts will not allow this. Although 703 technically says you could do it. If the expert quotes or relies on constitutionally inadmissible evidence, prosecutors in drunk driving cases where illegal searches have led to evidence, or let's say drug cases, those are the easy cases. Prosecutors in drug cases where there was an illegal search have brought experts in who will testify that they conclude that there was drug residue in the car. And the objection is, well, wait a minute, that was an illegal search. And the response is, 703 says the evidence need not be admissible in order for an expert to rely on it. Right? Very clever. But some courts have said, you know, that would really be kind of sleazy, and it would undermine the whole basis for the constitutional protections, so that's not okay. All right? And finally, the expert relies on inadmissible evidence, and you can argue, and part of this is in 703, and you can argue that it undermines the defendant's confrontation rights. And it undermines, it essentially causes prejudice. Okay. Well, why is this different? Notice you'd say, well, wait, this is constitutionally inadmissible. You're just repeating yourself. But this is a little different. This is evidence that would not violate the defendant's confrontation rights if the person who made the original statement was here in court. So basically, the way you argue this is that if an expert is going to rely on another person, you make the argument that it's inadmissible, even under 703, because you say the defendant has a constitutional right to cross-examine that original person who the expert is relying on. Okay? And of course, you can only do this in a criminal case because defendants only have confrontation rights in criminal cases. Although in a civil case, you could argue it as a due process claim. And beyond the legal doctrine, as an intuitive matter, you'd say it's not fair. You'd say to the judge, it's not fair. The expert is, you know, maybe he's not solely relying on this other expert, but a lot of what he's saying is just based on what this other expert says. I have a right to ask that expert questions, and you should not allow them to get around my rights to cross-examine that witness. And a lot of judges will be sympathetic, because it is a sympathetic argument. Okay? Any questions? I know this is a lot of doctrine. No? Everything clear? Why don't we take our break and then come back in 10 minutes and we'll do some more rules and hopefully have time for our clip. So come back at about 11:47. Okay, are we good? Okay, we should get started. So please go back to your seats. And okay, I'm going to get started again because we have a lot more doctrine to get through. So, you guys, let's go. So I'm going to give you the text of Rule 704 and then let you know what you need to write. This is called Opinion on Ultimate Issue. And it says that except as provided in subdivision B, and just let you know, B was something that was added by Congress in the 1980s, and it's kind of an interesting story. Testimony in the form of an opinion or inference otherwise admissible is not objectionable because it embraces an ultimate issue to be decided by the trier of fact. And what you want to write is this, is under 704A, testimony may embrace ultimate issues if otherwise admissible. So experts can testify. Actually, it doesn't have to be an expert. Anybody can testify as to an ultimate issue. It basically repeals a common law rule which said that you could not testify to ultimate issues. And of course, what is an ultimate issue? That's the question that everyone immediately asks. And one way to think about it is it's an issue that can make or break the case. That's ultimate. You know, the ultimate sport is sports that can break your bones. It's a good way to remember it. You know, it doesn't say, doesn't care whether it's an expert or not. I never thought about that. And an example would be whether the defendant had the requisite mental state to commit a crime. Well, as you'll see, this isn't a great example because 704B came about. Another example that is still good is whether someone's blood alcohol level was high enough such that it would violate the law. So in my opinion, his blood alcohol level was X. Objection, that's an ultimate issue. Objection overruled. Okay, but what about this example where the defendant had the requisite mental state to commit the crime? It turns out that 704B says, well, that's the kind of ultimate issue that we won't allow. And this is what happened. I think it was 1982, Ronald Reagan was president, and a guy named John Hinckley went to see the movie Taxi Driver and became infatuated, as was, what was his name? Travis Bickle was the character, was the taxi driver who becomes infatuated with a teen prostitute, Jodie Foster, who you, of course, think of as, you know, like your mom. But at the time, she was young enough to portray a teen prostitute. And Hinckley developed an obsession with her, wanted to be with her. He would call her in her dorm room, I think it was at Princeton, harass her. She got a restraining order. He wanted to prove his love to her, and he decided that the best way to prove his love to her was to assassinate Ronald Reagan. He was caught, tried, and they tried him in Washington, D.C., which had a rule that you had to prove beyond a reasonable doubt that the defendant was not insane. And both given the fact that D.C. juries are a little more difficult to convict in front of, and the fact that they had this very pro-defense rule, he was found insane, and to this day, he is committed to a mental hospital. But that outraged the public because they thought a not guilty due to insanity verdict was a not guilty verdict. And Congress stepped in, and Congress said, what do we do? Oh, let's amend 704. Of course, that's what I'm sure all of you immediately would think of. Let's amend 704, and let's amend 704 to add a requirement that No expert witness testifying with respect to the mental state or condition of a defendant in a criminal case may state an opinion or inference as to whether the defendant did or did not have the mental state or condition constituting an element of the crime charged or defense thereto. And what you want to write is this: under 704B, experts may not testify whether a criminal defendant had the mental state or condition constituting an element of the crime or defense. Okay, so mens rea, terms you learned in criminal law, right? Premeditation, understanding of the wrongfulness. That probably would be excluded. But notice that an expert can get very close to the point of saying, I conclude that he was not responsible for his actions. In fact, most of the testimony in the Hinckley case would still have been allowed. He probably still would have been acquitted, and it wouldn't have made any difference. But Congress, you know, they have to look like they're doing something. So the fact that he's a paranoid schizophrenic, that would still be admissible. Because notice that you're not saying something legal there. You're saying something psychological. Can they discuss the fact that he felt driven by compulsions to prove his love, his fantasy love for Jodie Foster? That would still be okay. And notice that you can come very close to getting to the ultimate issue. So whether he felt compelled by his hallucinations to try to assassinate Reagan sounds very much like saying he was not responsible because he couldn't appreciate the wrongfulness of his actions, right? Which is the legal standard. But courts will allow you to get very close, in part because courts didn't like 704B. You know, it's Congress. Congress is responding to political pressures of the moment and being kind of silly. So although 704B exists and it might limit you in some criminal cases, it really doesn't do very much. So the bottom line is, experts can say, in my opinion, he's responsible. Yeah? Yeah, great question. So let's look at that. See if it would require. So if we go to the rule, because we don't always want to look at the exact language of the rule. Did or did not. So, and it was actually, Park Dietz was a famous forensic psychologist who testified in the Hinckley case. He said, I think he had, you know, the necessary mental equipment that he could choose right versus wrong. And you're exactly right. Prosecutor would be barred just as much, and prosecutors would not be happy about that. Although, what prosecutors would say is, you know, if we could just get rid of all these experts, then we could get convictions. Because if the jury just goes by their intuitions, they're going to find them guilty. Once you get an expert into the case, then the jury gets screwy, because they start deferring to the expert. And usually the prosecution will only present an expert if the defense does first. So technically you're right, although I think as a practical matter, prosecutors were happy with this change. Okay. Now there still are potential limits on ultimate issue testimony, but not inadmissible on the face of 704. So you have to come up with a creative alternative explanation. Legal opinions. There's a famous case where a Harvard law professor was called as an expert witness in a tax case. And the judge, probably not having gone to Harvard, was insulted and said, I'm not going to allow him to testify. He wanted to testify about whether or not a certain deduction was allowable under the regulations of the tax code. Well, the person offering him, I think it was the defense said, look, 704 says ultimate issue doesn't matter. Court said no. The ultimate issue to be decided by the jury is what's allowable under 704. But this expert is testifying to something that is a matter for a judge to decide. The judge tells the jury what the law is. And although the old language of invading the province of the jury, remember how archaic I said it is, and that applies to 704 as well as to 702, invading the province of the judge is a different matter altogether. So if you can cast your objection not as an objection to what the jury can or cannot hear, but it's an objection that it will conflict with the judge's instructions, then you still have a potential ultimate issue objection. Okay? Now, of course, you immediately think, well, what is a legal opinion and what is a factual opinion? And that makes great fodder for exams and for real life. But you're not in real life yet. So think about the exam. One leap at a time, right? Credibility judgments. All of you can dream, right? I'm on the freeway this morning and I'm behind a guy in a convertible, and he's got the, the top down and the music on really loud, and around the little license plate it says USC Law. Yeah, all right. But he had to pass the bar first. Okay. Credibility judgments are still potentially objectionable. Whether an alleged victim is telling the truth is still potentially objectionable. Now, whether a witness is telling the truth is obviously an ultimate judgment in many cases. Many cases it will make or break the case. Is the defendant lying? Well, great. The prosecutor should just bring in an expert and say, I'm an expert in truth-telling. I've watched him on the stand, and I think he's a liar. Courts will not allow this. Now, part of it is they'll say that there's no scientific validity for this sort of determination. But, if you really look into it, actually, jurors are terrible at telling truth versus lies. They're at chance. Experts, at least if you allow them to, say, take a polygraph, are pretty good. Polygraphs are better than chance. They're not awesome, but they're better. But polygraphs are, time after time, not allowed into court. And in part, courts will say it has insufficient reliability, but they can't really mean that because it's better than jurors. And so what they ultimately fall back on is it's an ultimate judgment, an ultimate opinion. But notice it has to be a special kind in order to apply 704 regardless. And it does because it goes to credibility. It goes to whether a person is telling the truth or not. And this is the area where you'll still get a lot of courts talking about the province of the jury. That is a special domain in which we still believe that lay people should be making the decisions, not experts. Okay? All right, let's do 705. 705 gets back to this problem that we discussed with respect to 703, which is the inadmissibility of the basis for the expert's opinion. Now, what the 705 allows you to get around the problem of the jury hearing inadmissible evidence. And I'll tell you what to write. Experts can give opinions without first testifying to the underlying data. Okay? They can give opinions without first testifying to the underlying data. And the reason why you have to have this rule is under normal circumstances, foundation would be required, right? Wendy testifies, Al killed Bob. Well, objection, no personal knowledge, no foundation. So you have to work through the basis for the knowledge. Similarly with an opinion, right? Expert says, I believe the defendant was paranoid schizophrenic. Objection, how do you know? That's a foundational question that has to be addressed. 705 says you don't have to address it. Okay? So what the Rule 705 allows the judge to do is to keep that inadmissible evidence away from the jury. The proponent can't say, I have to offer this because I have to give the foundation for my expert's opinion. But then, of course, the problem now is, do we really want the jury to hear about this opinion without knowing the basis for the opinion? How can the jury decide whether they accept the opinion or not? And if you're cross-examining the expert, maybe you want the jury to hear the bases. And that's what this next line allows for. Experts can be cross-examined about the underlying data. So the opponent has a choice to make, right? If an expert comes into court and is relying largely on inadmissible evidence, you as the opponent have to decide, what are you going to go after? If you go after the inadmissible evidence, if you do everything you can to keep it out, then you would prefer to have the expert say, I believe X, nothing more. No basis for the opinion. Because as soon as he gets into the basis, the inadmissible evidence is out of the bag, right? Not a great choice. So then the option is, you want to go after the basis for the opinion, and you'll cross-examine him. But in doing so, you necessarily will reveal the inadmissible evidence to the jury. So case by case, as an opponent, you have to decide what's more valuable. And you may end up deciding that it really is good to just have the expert come in, I think X, not ask him any questions, and the jury will say, well, how does he think X? And they won't give him any credence. But it's up to you. Okay? Yeah? What do you mean by anything? Like, yeah. Well, I shouldn't say it so quickly. There is the rule that the redirect has to be within the scope of cross. So it has to be within the scope. But let's say the cross-examiner says, didn't you base your opinion in part on X, which is inadmissible, and then examines him further. It would be within the scope for the redirect to say, well, was there any other basis for your opinion? Right? So to that extent, yes, everything is subject to question. Right? Okay, let's talk about one Supreme Court case that, until Crawford, was the most important evidence case to come out of the Supreme Court, and I've already described the history. Daubert was the Bendectin case, and Bendectin was a great drug for plaintiffs because it was a drug that you would give women for nausea during their pregnancy. And just as a matter of course, one could predict large numbers of women having birth defects who had taken Bendectin. And why is that of course? Because Bendectin became the most popular drug for prenatal nausea. Prenatal nausea is very common. You know what I'm talking about, right? Even if you've not had a baby, you've been around someone who has a baby. And you know how usually I think it's the first trimester is the worst for nausea. So women would take this drug during the first trimester. I think over 20 million women took this drug. And if you just look at the rate of birth defects, one could predict that 2,500 women who had taken Bendectin would have a birth defected child, right? And all 2,500 will say, how could this happen to us? Now, of course, the vast majority of these cases would be just, genetic or environmental, nothing to do with Bendectin. But that's a lot of cases that are potentially actionable. So a lot of these cases got into court. The epidemiologists did what I told you they did. Case came up before the Supreme Court. Supreme Court really didn't want this case to go to trial based on what they thought was hired gun testimony by these scam epidemiologists. And so what the court needed to do was to find a basis in 702 for restricting expert testimony. Now, the technical issue in Daubert was whether the Frye test for novel scientific evidence survived the federal rules of evidence. And I've got to say something about this because, unfortunately, in California, the Frye test is still the standard. So I'll teach you a little California law. What the court in the Supreme Court case of Daubert said is, no, Frye is no longer good law. But you can immediately forget that holding. Because as you'll see, what the court did is they basically said Frye is overruled, and what we really have is Frye plus. Okay? So it was one of those apparent victories for the plaintiff, but it was really a defeat. Okay. Well, then why do I tell you about Frye? Well, Frye is still, in some ways, part of the FRE, the Federal Rules of Evidence, and Frye is definitely part of the California rules. And here's what the Frye test says. In order to admit evidence deduced from a scientific theory, that theory must have gained general acceptance in the particular field to which it belongs. And it's actually a case that's almost, almost 85 years old now. Just a DC Circuit case. But it's probably the most commonly cited DC Circuit case because this became the rule in most courts and is still the rule in California courts. And basically, if someone comes in and they're not just an expert witness, but they're a scientific witness, so you have to know what does science mean, then you have to have an extra hurdle to jump. And that extra hurdle is that you have to prove general acceptance. Okay? Now, here's where you want to stop and review what you think you know already. You might say, hey, wait, general acceptance is already part of the rules for experts, right? Because you have to prove that when the expert said something, he or she relied on what other experts believe, right? Does that sound plausible? So you say, wait, this is already part of the rules. You taught us this. But no, that's 703, and that only applies if the expert wants to rely on inadmissible evidence. So that general acceptance rule that already exists only applies to experts relying on inadmissible evidence. What Fry does is Fry says, anytime the expert claims to be a scientist or to be working with scientific information, you have to prove that other scientists would say, this is good science. Okay. Now, I'm going to skip over a couple of slides because I want to get to the punchline. Here's what the court did to get something back into the rules that didn't exist there. Now, you remember this, right? You've seen this. You've seen this. This is Rule 702. And this is all the court had to work with. And the court, based on 702, said, we have to establish scientific validity. Scientific validity is a question for the judge. And it's really a lovely opinion to read because it is so crafty. What the court did is the court pointed out that the words scientific and knowledge were in the rule. And based on those two words, it put them together, scientific knowledge, and then it said, what is scientific knowledge? And if you think about it, scientific knowledge is scientific, right? And it's knowledge. And based on those two words, Blackmun, the judge at the time who wrote the opinion, who's now in a better place, Blackmun said, okay, what's scientific knowledge? Well, you know, I got my math BA from Harvard, and I'm going to tell you what scientific knowledge is. And then created, basically out of nothing, well, I should say out of the very smart brief submitted by the, I think it was the respondents in the case, created all these new rules that would apply. So it has to be scientific knowledge, right? And what is scientific knowledge? These are the rules for scientific knowledge. And basically, what he did is he cited lots of philosophy of science. And these rules are added to the rules that already exist under 702. And even subsequent to the amendments to 702, which were largely in response to Daubert, these rules apply. So you'll see judges trying to talk about the issue of falsifiability, which is a theory of science issue that is actually difficult to understand, right? The example I can give you of non-falsifiability is if your doctor says to you, and this came up a lot in the 90s, the doctor says to you, you know, I think you were sexually abused as a child. And you say, but I have no memory of it. And the doctor says, that proves it, right? Repressed memory. And in fact, the fact that you resist proves that it happened. And then you finally come to accept it. Well, does that prove now that it didn't happen? No. Expert still thinks it happens. So notice that it's non-falsifiable. You say it didn't happen, you're resisting. You say it did happen, it did. Non-falsifiability. So it's non-scientific, although most judges don't understand that. And even in Daubert, Rehnquist said, I don't know what this is. Has the theory been subjected to peer review and publication, right? So you look at whether the theory has been published. So the way that the epidemiologist in Daubert was kept out was, although she was a scientist and had reviewed the scientific validity of other studies and doing her own what you call meta-analysis, she had never published her results. Ninth Circuit on remand said, goodbye, that's all we need to know. What is the rate of error, right? How often does this technique make mistakes? And that's kept out the polygraph in many cases because it does have an identifiable rate of error. And are there standards for the technique's use? Are there manuals that tell you this is the right way to administer this type of test? Okay? And, of course, as I've already told you, and Blackman said, and finally, we decide if something is science if it is generally accepted, which was the Fry rule that in the beginning of the opinion he said had been repealed. Overturned, you would say. So when you confront scientific evidence, when someone is really talking like a scientist and not simply based on their experience or even their education, then you apply the rules of Daubert and you can go way beyond the usual 702 language. Okay. Now, this is this issue of fit, which is also discussed in Blackman, but I wouldn't try to learn this independently of this part of 702. So does the testimony apply to the facts of the case? You can use the term fit, but think of it as that third part under 702. So I won't belabor that point. The questions that have come up is, can courts consider even more factors? Are they limited to peer review, falsifiability, commonly accepted? You know, I'm doing the, can I remember these rules? Can they add more of their own? And the answer is sure. So I think it's the Third Circuit had a list of 12 rules for scientific testimony. And what's great is the more rules you have, the more rules experts can potentially violate. So although Daubert supposedly opened the doors to expert testimony, and it's funny, many of my psychology colleagues will refer to Daubert as, you know, opening the floodgates to junk science. It had the opposite effect. It created new ways that you could keep experts out because the list goes on and on of what constitutes scientific. So this standard, whether the theory was an anticipation of litigation, was one that the Ninth Circuit added to the list when the case was remanded to them. And they did this as another basis for excluding this epidemiologist because she was hired by the plaintiffs, and therefore she was doing her science in anticipation of litigation, and we know from the business records exception that that's a reason for not believing something. Okay? Can courts use 403 to exclude expert testimony? Or is 702 now the exclusive grounds? And the answer is yes, they can. And in fact, Daubert says you have to be especially careful, and this is the point I've raised before, which is because jurors like to defer to experts, right? Because jurors like to defer to experts, they are prejudicial, right? Because if a juror defers to an expert, because he's an expert, they're not using appropriate grounds for assessing the evidence, and that's a 703 problem. And then finally, the last question that's come up, or I should say the most recent question, is, well, what if it isn't even scientific? Now, be careful here. In California, Fry is explicitly only scientific evidence. Under the federal rules, what does the court say? The court says yes. So the rules of science can potentially be applied to non-scientific experts. And in Kumho Tyer, I think he was an engineer. And engineers always talk about where the rubber meets the road, so they know about this stuff. He was talking about whether the tread wear was normal or whether it was due to misuse. And he really had no basis for his opinion. And what the court in Kumho Tyer said is, okay, he says, I'm not a scientist, but we're still going to apply the rules that Daubert came up with. But again, the court does have some discretion. Okay? That's a lot of material, huh? I'm sorry for that, but that's the nature of expert testimony. So when you're trying to get your head around all of this, definitely you have to learn the 702 rules. You want to think of this as facts, right? Theory and application, or fit. You want to get your head around that. And when you're confronted with something that is clearly of a scientific nature, then you want to throw out some of the Daubert objections. But the extent to which you really learn Daubert is something that will, I mean, I don't worry about it as much for testing, But that's something that definitely, once you're out in the world, if you do any kind of litigation work with injuries, you're going to get into Daubert, you're going to get into scientific evidence. And as you know, an expert is the best thing you can have. So these rules will come in very handy and very important. We only have a few minutes, so I can't really get to the hypo. I'll look at Monday's schedule, see if I can show it to you then. But that's all for now.